This is part 8 and the conclusion of contracts, beginning with restitution. This is where the defendant is unjustly enriched. The plaintiff can recover the value of the benefit conferred. There's an increase in value of property or cost of obtaining a benefit from another person, not the plaintiff. Under the UCC, the failure to tender and buyer's remedies under the UCC. This is damages. This is the market price, and that is measured at the time of breach minus the contract price. A cover is a purchase of similar goods, and recover replacement price. So cover is where you purchase similar goods, you can recover the replacement price. Specific performance may be a remedy where they are unique goods. Nonconforming tender and buyer's remedies under the UCC. You have a right to inspect, then a right to accept and or reject all and or part of the goods. Payment does not constitute acceptance if there is no right to inspect before payment. Rejection, nonconforming tender and buyer's remedies under the UCC. A valid rejection constitutes notice within a reasonable time before acceptance. May retain possession for a reasonable time for seller to reclaim the goods. May store those goods at the seller's expense. In the absence of other instructions in regards to perishable goods, those perishable goods must be sold on the seller's behalf. Now there are same remedies where you reject as if there was no tender made. So you inspect the goods, and you reject the goods. You can treat that as the same as if no tender was made, and you have the remedies of damage, cover, specific performance. Looking at acceptance of non-conforming tender and buyer's remedies under the UCC. Expressly stating acceptance acts as acceptance. Using the goods acts as acceptance. Failing to reject the goods acts as acceptance. You may revoke acceptance if acceptance is on a condition seller would cure defect that was hidden. Now, looking at the right to cure in non-conforming tender buyer's remedies under the UCC. The seller has a right, if time for performance has not elapsed or has reasonable grounds to believe buyer would accept the cure despite earlier nonconformity, seller must give notice of the intent to cure. This is right to price upon acceptance and seller's remedies under the UCC. The seller has a right to the price after tender and inspection unless the contract provides otherwise. Right to reclaim goods and seller's remedies under the UCC, where the buyer is insolvent, purchased the goods on credit, and the seller learns of insolvency, the seller may reclaim the goods if demand is made within 10 days after buyer's receipt of goods. Again, demand must be made within 10 days after buyer's receipt of goods. Now, this 10-day window does not apply if the buyer misrepresented solvency in writing. That misrepresentation must be in writing within 3 months before delivery. Stoppage of goods in transit and the seller's remedies under the UCC, where there is a buyer's breach. Stoppage of goods in transit is only available if shipped in large lots, such as a train car or truckloads. In regards to buyer's insolvency, you can stop goods and refuse delivery except for cash. And shipment can be of any size. So where the buyer is insolvent, you can stop the goods and refuse delivery except for cash, and this can be of any sized shipment. Where the buyer breaches, you can only stop it for large lots. Risk of loss under the UCC, Generally, the risk of loss is on the seller until the seller satisfies the contract delivery obligations. In regards to that, shipment by third-party carrier and risk of loss under the UCC, you have a shipment contract. This is where the contract does not specify a place for delivery. The risk passes to the buyer when the seller gives goods to the carrier and makes a proper contract for the shipment. That makes sense because you haven't specified a place for delivery. How can the seller be responsible for getting them where they don't know that they're going? Here the UCC considers this the normal agreement and or risk of loss, meaning under the UCC the majority is that the risk passes to the buyer when the seller gives goods to the carrier and makes a proper contract for their shipment. So that's a shipment contract. Then you have a destination contract. This is where the contract specifies delivery at a particular location. The risk passes to the buyer when the seller tenders at the specified place or the place specified in the contract. And that completes all of contracts.